Governments protecting their own with mock trials is nothing new. When our founding fathers published the Declaration of Independence, they listed 27 specific grievances against the king, including for protecting the military by mock trial from punishment for any murders which they should commit on the inhabitants of these states. Today, courts are protecting law enforcement by mock trial from punishment for violating the law and rights based solely on their opinion of what is clearly established statutory or constitutional rights. The Supreme Court recently opined on two cases where the question of a law enforcement officer's qualified immunity was in question. But we really have to ask ourselves two questions. First, is it constitutional to provide government officials with special treatment under the law? And second, do the courts have the legal authority to determine when statutory or constitutional rights have been established? So we'll discuss that next on the Constitution Study.
You have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free, and we teach the people to live as free citizens. I'm glad you could join me. As always, if you want more, head to constitutionstudy.com. That's got all the information, articles, videos, podcasts, everything you could want for studying the work that we're doing here at the Constitution Study. Now, I'm going to be in Tampa November 9th and 10th, and I'm trying to set up some more dates. So if you're in the Tampa area, well, please check out constitutionstudy.com/tour and see if you can join me at one of those events. Also, if you live anywhere between Nashville, Tennessee, and anywhere in Florida, and you'd like me to come speak to your group while I'm down there, go to that website, go to the bottom, and fill out the form. We'll see if I can visit and speak to your group as well. Now, I've got some more information about the websites. I'll talk about that at the end of the video, but right now, let's talk about this qualified immunity. One of the most important rights we have is a right to petition our government for a redress of grievances. Now, while there are many ways to petition, one of the most common is to sue in court. I mean, after all, courts are one of the three branches of government. So when you sue someone, you are petitioning your government for a redress of some grievance. What happens, though, when those courts shield government actors from the consequences of their bad behavior? That's exactly what's happened with the doctrine of qualified immunity, which is defined by the Free Legal Dictionary as, in the United States, qualified immunity is a legal principle that grants government officials performing discretionary functions immunity from civil suits unless the plaintiff shows that the official violated, quote, clearly established statutory or constitutional rights of which a reasonable person would have known, close quote. Like so much of what goes on in the judicial branch of our governments today, qualified immunity is not a law. Rather, it is a standard made up by the courts for their own reasons. Now, originally, the idea of qualified immunity was based on two factors: the good faith and the reasonableness of the conduct in question. For example, if a law enforcement officer is given a warrant to arrest someone, most would generally believe that it has been legally issued. Therefore, if they executed the warrant and then it was found out that at trial the warrant was not legally issued and the defendant sued the officer for false arrest, qualified immunity would protect the officer. In this case, the officer made the arrest in good faith with the reasonable belief that the warrant was valid. In the 1982 Supreme Court case, Harlow versus Fitzgerald, the court was concerned about the subjective aspects of a person's state of mind. How are we to know if the agent was acting in good faith? That would require a trial, probably by a jury. The court expressed concern that these trials diverted official energy from pressing public issues and deterred able citizens from accepting public office. So the court decided to change the standard of qualified immunity to the one quoted above. Now, while the language seems pretty straightforward, the problem comes with who the court uses to determine what is clearly established statutory or constitutional rights of which a reasonable person would have known. See, the answer is not the Constitution or the laws of the United States, but rather the opinion of judges. See, this has not only led to some truly crazy and bizarre decisions, but some horrendous violations of the rights of the American people. Which leads me to the two cases the court recently opined on. Now, while the outcomes in both of these cases are reasonable, they show how the courts have replaced the supreme law of the land with their own opinions. First, the case of the city of Tulahua, Oklahoma versus Dominic Rollis. Officers were called to the home of Dominic Rollis' ex-wife, Joy, after she called 911. Mr. Rollis was in her garage intoxicated and refused to leave. Joy led the officers to the side entrance of the garage, where they began speaking with her ex-husband. Mr. Rollis expressed concern that they were going to take him to jail. The officers assured him they only wanted to get him a ride. One officer asked Mr. Rollis if he could pat him down for weapons, which Mr. Rollis refused. Body cam footage shows Officer Gardner gesturing with his hands and taking one step toward the doorway. Mr. Rollis reacted by taking a step back, turned around, and walked toward his tools, which were in the back of the garage. The officers followed Mr. Rollis, but maintained a distance of at least 6 feet. Mr. Rollis picked up a hammer, turned, and held the hammer as if preparing to swing or throw it at them, which prompted the officers to draw their weapons and yell at Mr. Rollis to drop the hammer. Instead, Mr. Rollis moved from behind a piece of furniture, giving him an unobstructed path to one of the officers, raised the hammer as if to charge or throw it, and in response, 2 of the officers fired, killing Mr. Rollis. Mr. Rollis' estate sued the 2 officers in federal court, claiming they violated his rights protected by the Fourth Amendment to be free from excessive force. The officers moved for summary judgment on the grounds of qualified immunity. At issue before the court was if the 10th Circuit's overturning of the district court's granting of qualified immunity was valid. Now, in the court's opinion, the answer was no. Not because they believed Mr. Rollis was the victim of excessive force or because they saw a violation of the Fourth Amendment. The court specifically stated in their opinion that they were not deciding either of those issues. The Supreme Court overturned the Circuit Court because they didn't use the right precedent. The 10th Circuit contravened those settled principles here. Not one of the decisions relied upon by the court comes close to establishing the officer's conduct was unlawful. Notice, it was not the law that determined if the actions of the officer was lawful or not, but the opinions of previous courts. And because the Supreme Court doesn't think that the law clearly establishes the rights of the people, the estate of Mr. Rollis is denied his right to petition the government for a redress of grievance. Next, the case of Daniel Rivas Villegas versus Roman Cortesaluna. I hope I got that right. The Union City, California police officer Rivas Villegas responded to a 911 call reporting that a woman and her 2 children were barricaded in a room, fearing that the woman's boyfriend, Mr. Cortesaluna, was going to hurt them. Officer Rivas Villegas and other officers commanded Mr. Cortesaluna outside and on the ground. While handcuffing Mr. Cortesaluna, officers noted a knife in his pocket. While removing the knife, Rivas Villegas briefly placed his knee on the left side of Mr. Cortesaluna's back. Now, Cortesaluna sued in federal court, claiming Officer Rivas Villegas used excessive force in violation of the Fourth Amendment. The issue before the Supreme Court was whether Officer Rivas Villegas was entitled to qualified immunity. Interestingly, the district court granted qualified immunity, but was overturned by the circuit court. The Court of Appeals held that Rivas Villegas is not entitled to qualified immunity because existing precedent put him on notice that his conduct constituted excessive force. In reaching this conclusion, the Court of Appeals relied solely on Lalonde versus County of Riverside. Now, one judge dissented, stating that there was insufficient details in the Lalonde case to make it clear to every reasonable officer what Officer Rivas Villegas did was excessive force. The Supreme Court agreed with this dissent. We agree and therefore reverse, even assuming that controlling circuit precedent clearly establishes law for purposes of Section 1983, Lalonde did not give fair notice to Rivas Villegas. He is thus entitled to qualified immunity. Now, in both cases, issues before the court was not the use of excessive force, but whether or not the officer was shielded by qualified immunity. Now, looking at it from the other side, the Supreme Court was deciding if the original petitioners would be granted their right to petition the government for a redress of grievances. In both cases, the court sided with the government. And in both cases, the court based its decision not on the law or the Constitution, but whether prior courts had decided what the officer did was wrong in a sufficiently plain manner. Does that sound like the rule of law to you or the rule of a few? Now, that's not all. How many of you have heard the phrase, ignorance of the law is no excuse? Can you get out of a speeding ticket because you didn't see the sign? Can you avoid the penalties or possible jail time because the IRS regulation you violated was not clearly established? Can you avoid a trial by simply claiming you had not been informed of some court opinion that found what you were doing was illegal? The answer to all these questions is no, unless, of course, you're a government agent. See, Article 6, Clause 3 of the Constitution requires that the oath taken by all executive and judicial officers include that they support the Constitution of the United States. Yet courts have claimed they only need to follow that oath if a previous court had clearly found the specific actions of those in government clearly violated the document. See, Article 6, Clause 2 of the Constitution states that it and the laws of the United States made pursuant to it are the supreme law of the land. However, the courts have placed their opinions above the Constitution and established themselves as the supreme law of the land. And just to add insult to injury, how is a court supposed to establish that the specific actions of government actors are a clear violation if those cases are never heard by a court? These two cases are more proof that the government in Washington, D.C. is now filled with criminals. Going to federal court for a redress of grievance today seems more like going to the Corleone house than a court of law. Your fate is no longer decided by the laws of the nation, but by the opinions of oligarchs in black robes. Once again, we see a government protecting their own from punishment by mock trial. So when do we declare our independence from this tyranny? When will we, the people, realize that the people we hire to represent us in Congress have the legal authority to deal with this gross miscarriage of justice? Not until we, the people, realize that, as Abraham Lincoln said, the people are the rightful masters of both Congresses and courts, not to overthrow the Constitution, but to overthrow the men who pervert it. Well, when it comes to the Constitution, there's a whole lot of perverting going on. There are plenty of perversions of the Constitution, and they just seem to pile on top of each other, which is why it's important that we, the people, learn for ourselves how to live free. What are the limits we put on government, including the federal courts? What powers did we grant them, and what powers do we deny them? And what do we do when a branch of government violates their oath to support the Constitution? All this is part of becoming a constitutional scholar, a student of the Constitution. Now, I've already mentioned Constitution Study, where you can find my articles and other resources for you to use and share. But if you want to become a student of the Constitution, if you want to be a scholar, well, head to constitutionscholars.com. That's the site I set up specifically for people who want to study the Constitution. Sure, you'll have access to a library of documents and some videos, and I'm working on even more courses. More importantly, though, you'll find the community groups, where you can find other men and women who are interested in reading, studying, understanding, and applying the Constitution of the United States. We walk around as if this magic document is going to somehow protect us from bad actors in government, forgetting that it's just ink on parchment. No, it is our tool, it is our permission, it is our legal justification to live as free people. To say, we didn't authorize government to do that, so we don't have to follow it. To look government square in the eye and say, no. But that comes with study, it comes with training, and it comes with a conscious decision of how far you wish to push that. So check that out, constitutionscholars.com. If you have any questions, that's a great place to ask, because you can ask, well, not just me, but other scholars. So join the group for your state and other topics of interest you may have. Of course, you can still go to constitutionstudy.com. You can ask a question there, or you can join my live Q&As that I hold the second and fourth Thursday of every month, 7 p.m. Central Time. You can find out more there at constitutionstudy.com. And you can watch them on YouTube, Twitter, or Rumble, whatever you prefer. But the important point is to first educate ourselves and then engage with that information. Thomas Jefferson said the proper correction of constitutional abuses is educating the people. That's what we're trying to do. So I hope you found this little piece of information useful. I hope you'll share it with others. I please ask you to share it. If you're listening on the podcast, then please go to Apple Podcasts, give me a rating and review. Help other people find this information I think is so useful and so important to the work that we do. And if you would, please join me here next time for the Constitution Study.
One thing you have to know wherever you make your stand came from